Are you divorced with young children? Or maybe you know someone close to you that is divorced with young children. Well, stick around. I am about to explain some things to take into consideration when dealing with divorce and young kids. Hello, thank you so much for joining me. I am the estate planning mom, and my name is Krista Hermans. I am an estate planning attorney licensed in California, and I help families protect their kids and their family through estate planning. Please make sure to click that subscribe button and hit that bell to be notified when new videos are released every Thursday. I would like to talk about divorce and young kids in reference to estate planning. So, today, approximately 42% of marriages end in divorce, and that's for first marriages. With a statistic so high, I think it is important that people know that they have options on how to put plans in place after they are divorced and when they have minor children. So, the first thing that I think is very important is updating any life insurance beneficiary documentation you have, as well as retirement accounts, so 401k, investment accounts, anything like that. And it can be a matter of going online and to the company where you have those policies and checking the beneficiary designation. And if it lists your ex-spouse, you want to make sure that you update it. I generally don't recommend clients update beneficiary designations with their minor kids because minor children cannot receive that money. But maybe somebody else that you have that's close and that you trust in your life, you can use them, or generally what I do recommend for clients is using a trust. So that's really important. Make sure that you update any of that life insurance or retirement account beneficiary information to remove your ex-spouse if that's what your intention is, and update it with who you would actually want to receive it. Okay, next. Any documentation that you may have completed, any estate planning documents in regards to power of attorney, advanced healthcare directive, a will, a trust, any of those documents that you may have, you want to review it to see, is your ex-spouse listed as an agent in any of those documents? If it is not your intention that they remain that agent, then you should update those documents with what your wishes actually are. So again, power of attorney, advanced healthcare directive, wills, trusts, anything like that, make sure to review it and see, does it need to be updated with somebody that you would trust in those positions? Okay, I want to share a story with you. And this story is about Beth. Beth was recently divorced. She had 3 minor children. After her divorce was finalized, she updated all of her life insurance documentation to her minor children. Beth passed away about a year after getting divorced, and her kids went to her ex-husband. And at that point, the life insurance policy that she had was then going to her kids. But since the kids were minors, the husband had to go through a guardianship or conservatorship to be able to get those funds for the kids. But then they were essentially his money to be able to use for the kids however he wanted, right? There's nothing in writing that says this is how the money is to be given to the kids. It just went to him, which is not what she wanted because she changed this beneficiary designation to the kids. But because there was no plan in place that said this is how I want my money distributed for my kids, it went to her ex-husband, okay? So that's one of the issues that people can have when they go through a divorce if they don't put the proper plans in place. So I'm going to share with you how to resolve that issue. One way to resolve that issue is by putting in place a revocable living trust. So a trust is essentially just a legal agreement where you as the grantor, which is the creator of the trust, put specific instructions in place to the trustee, which is the person who agrees to hold legal title to the assets in your trust. And they do this for the benefit of the beneficiaries. So all 3 of those roles, the grantor, the trustee, and the beneficiary, while you are alive with a revocable living trust, you are all 3 of those roles. You're not losing any access to your stuff. You're not losing any control. You still have complete control over all of the stuff in your trust. There's just a plan in place that if something were to happen, whether incapacity or passing, that your instructions would be followed, okay? So when you have a trust, it allows you to list what's called a successor trustee. And the successor trustee is somebody that you trust that would manage your instructions, your trust, after something happened to you, to be able to manage it to with whatever instructions you had. So in the example with Beth, if she had had a trust in place, she could have listed a successor trustee that was maybe her parents or a sibling that would manage the trust. In that case, it wouldn't have gone to her ex-husband, right? Because she had this trust where she had a successor trustee that was actually managing the assets for the kids. Okay, so that's what a successor trustee allows you to do with a trust. The other portion is that when you have a trust, it allows you to list the trust as a beneficiary on your life insurance policy and your retirement accounts. So that if the kids are minors, rather than the money going to them and then potentially going to the ex-spouse because the kids are minors, that money is going into trust for them to be distributed however you put in place them to receive that money. And maybe in the trust you put up that you don't want them to receive the money until they're 25, 30, and 35. You have the ability to put that in the trust to be able to make sure what you want is actually done. And having a trust, you can put specific instructions of what you want that money used for. So maybe you want it to be there to help with the kids when they go to college, or to help them purchase their first home, paying for a wedding, starting a business. You have the options, okay? And by having a trust, it allows you to put those specific plans in place. Another really important factor, I think, of having a trust and dealing with minor kids and having an ex-spouse is that by having a trust, all of that money that you have that's going to the kids, that's going through trust, avoids having to go through probate. And if you've heard anything about probate, you probably haven't heard the greatest things. But in California, the probate process can take anywhere from 12 months to 2 years to complete. It's very expensive. The kids might not have access to money during the time of the probate, and it's completely public. So by having a trust in place for the protection of your kids, if something ever happened, it would help avoiding that probate process and save money for your kids at the same time. Okay, so if you are divorced and you have minor kids and you're not really sure where to start, don't worry, we are here to help you. So please reach out to us so that we can help you get started and figure out what's the best plan to have for you and your specific situation. Thank you so much for joining me, and don't forget to click that subscribe button and hit that bell to be notified every Thursday when we release videos. And if you have any estate planning questions or comments, please reach out to us or comment below. Have a great day.